We provide bold,
legal insight and business leadership
to forward-thinking people and organizations.
We believe in better
and bold outcomes
and meticulous focus
in finding the solutions others might miss.
By building our practice around the best minds in the legal profession.
And outside of it too.
We believe the pursuit of better starts with people.
Our colleagues, our clients,
and the people who depend on them.
We are committed to truly understanding
the individual needs
of those who depend on us,
so we can help them go from where they are
to where they want to be.
We are.
We are.
We are.
We are.
We are.
Husch Blackwell.
Husch Blackwell.
Husch Blackwell.
We are Husch Blackwell.
Hello everyone, this is Demetrius Peterson, Senior Counsel in Husch Blackwell's Higher Education Group. Before we begin, I would like to cover a few housekeeping items. At the bottom of your audience console are multiple application icons for your use during the program today. I would like to take a minute to highlight a few of the key icons for you. If you have any questions during the webcast, please submit your question via the question box. We will try to answer all questions during the webcast today, but if a fuller answer is needed or we run out of time, it will be answered later via email. We truly appreciate audience participation and encourage you to submit questions. A PDF of the presentation is available in the resources folder. This program is pending approval for continuing legal education credit. To report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Toward the end of the program, be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your business needs. That is all of the housekeeping items. Let's get started with our program today. Joining me today is Teresa Molyneux. Teresa has a particular affinity for educational matters. Teresa counsels educational clients, conducts athletics, Title IX, and increasingly common historical misconduct investigations. She advises administrators and staff to ensure their compliance with numerous state and federal regulations, including Title IX, Title IV, the Individuals with Disabilities Act, the IDA, Section 504 of the Rehabilitation Act, the Americans with Disabilities Act, and the Family Educational Records Privacy Act, FERPA. And so, with that, let's get started with our program today. We are going to have a few poll questions throughout the program today, and I want to start off with one. I'll give you an easy one as we start off. So, how familiar are you with the ADA? I have a thorough understanding of the ADA because of my job. It's one choice. I'm familiar with the ADA, but I'm not an expert. Or I know a little bit about the ADA, but would like to learn more. Give you a second to enter your answers. Okay, so it looks like the majority of our group has some familiarity with the ADA. Well, I guess yes, but there's some people that might not have as much of a background with the ADA as others, and so I'm going to start today with a little bit of an overview, which is going to be a review for most of you, it looks like. But I wanted to kind of lay a foundation before we get into some of the case law updates. So this is the text of the Americans with Disability Act. It's from the U.S. Code, and it says, no individual shall be discriminated against on the basis of disability in the full and equal enjoyment of goods, services, facilities, privileges, advantages, or accommodations of any public accommodation. And so that's this is from the bill that was passed, the Americans with Disability Act in 1990. It was passed as a result of a lot of advocacy groups, a lot of protests from individuals with disability, and this is where the ADA comes from. Also here, I think it's important as we engage in this discussion as educational institutions to remember that there is also another federal law that prohibits discrimination on the basis of disability as well, and that is Section 504 of the Rehabilitation Act. And the general purpose of both of these acts is to eliminate discrimination and exclusion from the benefits of services of the program or activities based on a disability. And so Section 504 would apply to public universities and colleges, universities and colleges that receive, both public and private, that receive federal financial assistance. The ADA is going to have a few distinctions. So Title I of the ADA would apply to employment issues. Title II would apply to public universities and colleges, and Title III would apply to private universities and colleges. And we'll talk a little bit about the enforcement of that here in a few slides. So it's important to remember this is about access. So both public Title II and private Title III schools must provide equal access to post-secondary educational opportunities. And then it's only required to accommodate students or report a disability or request help in the post-secondary situation. And this differs if you are someone, and we have a variety of educational institutions on, and so if you're at a K-12 school, this is going to be a little bit different. Post-secondary, those of us who work in post-secondary, at post-secondary institutions, we know that students must come to you and report that they have a disability and request assistance. And that differs from the obligations for K-12 institutions. K-12 has requirements under their child find in the IDA, and that requires K-12 institutions to find students with disabilities and provide services. So it does differ a little bit in the elementary and secondary and post-secondary context. So the U.S. Department of Education's Office for Civil Rights is responsible for enforcing both Section 504 and Title II of the ADA. I had experience working in the Office for Civil Rights for about 6.5 years before coming into private practice. And just from my experience and my experience currently working with our clients on matters with the U.S. Department of Education, the majority of complaints that office receives would be discrimination complaints. And so I just wanted to just make that point that these are the majority of OCR cases or cases of disability discrimination. Most concern the identification of students who are protected by Section 504, and that means they're trying to obtain the appropriate education resources for their needs. And so those would generally be in the K-12 context, but we do receive a lot in both the elementary and secondary and post-secondary complaints that would be failure to accommodate or failure to provide the accommodations after a student were to go through the post-secondary accommodations process. So let's start off with the basics again. So what is a disability? A disability is a physical or mental impairment that substantially limits one or more major life activities. The student also, or the individual also must have a record of having the impairment that limits the major life activity, or be regarded as someone that has the impairment that substantially limits the major life activity. So the next question when we're going through this is, what is a major life activity? And it's a very broad list, and this is not an exhaustive list. But sitting, standing, reaching, concentrating, communicating, the ability to control your bodily functions, the ability to breathe, the ability to speak, the ability to hear, walk, those have all been determined to be major life activities. And so it's very broad, the interpretation of what are those major life activities. And so when we talk about the prohibitions, the ADA prohibits denying participation. It prohibits providing an unequal benefit to individuals with disabilities. It would prohibit providing a separate benefit to individuals with disabilities. So the ADA mandates that individuals with disabilities be permitted to enjoy the same benefits and privileges as non-disabled individuals. And so we need to think about that as we are reviewing our processes and addressing these types of issues. And so what are the requirements that we have as institutions? We must make reasonable modifications to allow access to individuals with disabilities. And remember I said this is about access, unless such modifications would fundamentally alter the nature of the goods, services, facilities, et cetera, or would result in an undue burden. And so I see this often, when a student were to request a specific accommodation, the short answer is, that institutions like to say is, well, this is going to create an undue burden. Certainly, I would qualify for an undue burden or undue hardship. And so as we go through that analysis, it can be kind of tricky. It's not as cut and dry as you might think. But the first thing you'll look at is whether or not the proposed accommodation would be significantly difficult or expensive to put into place. And so, just because something, may cost the institution, a ton of money, that doesn't necessarily mean that it's going to be an undue burden or undue hardship. So you're going to look at the nature and cost of the accommodation. You're going to look at the financial resources of the institution. And notice there, I think the key point there is noticing that it says institution. A lot of times these accommodations may be provided or requested of a specific academic program or specific school on your campus. And just because the school or the academic program has a limited budget, when DOJ in some instances or EEOC or OCR, when that's being evaluated, they're going to look at the financial resources of the entire institution. And so that just cost alone, that can be difficult and it can be tricky. So you need to look further than the more narrow budget of a specific program. Also, another thing that's going to be examined is the impact of the accommodation on others at the institution. So what isn't required here? You're not required to provide an unfair advantage. You're not required to provide an extra perk. And you're not required to meet a student's precise demand. So if a student comes to you comes to the disability services or to a professor and says, I am entitled to this specific accommodation because I have this disability, you aren't required. What's required under the law is to engage in an interactive process. And as you go through that interactive process with students, you can request additional documentation. You can request additional support. You're going to look at how can the student's disability be accommodated. And so just because, and even I've had situations like this where you get a specific accommodation from a medical provider. Nothing would prohibit you from asking for additional clarification, asking for additional support, or in certain circumstances, maybe requesting, that the student go through and provide additional documentation from a specialist. Let's say the student has a hearing issue, but the accommodation was put into place by their family doctor. And there's situations like that where you may request additional information from a licensed audiologist. And so those are all things to think about. And so flexibility and problem solving are key to accommodating students in an equitable manner. So now I'm going to pass the baton to Teresa to discuss some recent updates in this area of the law.
Thanks, Demetrius. Like Demetrius said, now we're going to focus on some recent case law and guidance that impact higher education institutions. But first, a refresher regarding service animals. So your institution is allowed to have a few requirements for a service animal. First, the service animal must be in control with devices if possible, or with words. They must be housebroken, and they must be in control, like I said. You cannot exclude service animals if they meet these requirements. Housing providers can also not charge a fee or deposit for any service animal. So what can you as a higher education institution ask about a service animal? There are only 2 questions you can ask an individual as it pertains to his or her service animal. The first is the animal required because of a disability? And the second is, what work or task has the animal been trained to perform? No other inquiries about an individual's disability are permitted. Additionally, businesses cannot require proof of certification or medical documentation as a condition for entry. And Demetrius and I see this come up a lot when our higher ed institutions are hosting events or concerts or things like that on campus where they are not necessarily campus community members, but they are on campus, these same two questions apply for those scenarios as well. So we have reached our second poll question, which is, are self-trained service animals protected under the ADA, or is formal certification required? I'll give you a second to submit your answers. Okay, so it looks like the majority of people answered self-trained animals qualify for protection. And this is true now in the Ninth Circuit. In a recent court opinion, the Ninth Circuit held as long as an animal is adequately trained to perform tasks related to the individual's disability, the animal need not be formally certified. So in the case CL v. Del Amo Hospital, Inc., there was a patient who had been diagnosed with PTSD, anxiety, and depression. And this patient was denied permission to bring her non-certified service dog into an inpatient treatment center for people who had experienced trauma. The center claimed the dog would interfere with the patient's therapy. The district court ruled that the self-trained dog was not a certified service animal under the ADA. The Ninth Circuit reversed this decision and held as a matter of first impression that the ADA prohibits certification requirements for service animals. Rather, the court held that the ADA requires only that an animal be trained. It does not mandate who does the training. In making this decision, the Ninth Circuit referred to subsection C6, which permits public accommodations to ask only two questions to determine whether an animal is a service animal, the same two questions I just discussed. The Ninth Circuit held that this subsection expressly prohibits any institution from requiring documentation, such as proof that the animal has been certified, trained, or licensed as a service animal. Our next poll question is, are universities required to provide accommodations to students during disciplinary hearings? Yes, no, or it depends. Okay, it looks like the majority of you answered yes. And the Eighth Circuit recently held that universities are required to provide reasonable accommodations that are requested in accordance with the ADA. In Rossley v. Drake University, a male student diagnosed with dyslexia alleged that the university violated the ADA by not granting him accommodations during a disciplinary hearing for sexual assault. However, the student had made no specific requests, formally or informally, for accommodation during the disciplinary hearing. In this case, neither the plaintiff or his representative explicitly requested accommodations for the disciplinary hearing, nor did they articulate how accommodations would allow him to better participate in the hearing. The Eighth Circuit held that a request for accommodation must be connected to the stated disability to receive accommodations in the hearing. The vague demands for time and a half for anything and everything that plaintiff requested were found to be unclear and unspecific enough to grant accommodations. So, even if the university is aware of accommodations in other contexts, specific requests must be made for each new accommodation, including in this hearing process, and the request must be specifically tailored to allow participation. Our next poll question is, does the ADA protect an employee who was allegedly fired based on potential exposure to COVID-19? Yes, no, or I don't know. Looks like the majority of you answered, I don't know, and that's likely because this is such a new area of the law. And there is a recent opinion from the Eastern District of Tennessee which found that the answer to this question is no. Possible exposure to COVID-19 is not a physical or mental impairment that substantially limits one or more major life activities and thus was not protected. Now, in this specific case, the plaintiff claims that his employer violated the ADA by firing him based on a perceived disability, which he alleged was possible exposure to COVID-19. The court rejected this claim because the plaintiff could not establish the first element of a discrimination claim under the ADA, which is that he was, in fact, disabled. The court held that possible exposure to COVID-19 does not constitute a disability under the ADA, and a terminated employee could not sue by arguing he was perceived as disabled due to COVID-19 exposure. Our next poll question is long COVID always a disability? And you might be wondering what long COVID is. According to the Centers for Disease Control and Prevention, people with long COVID are those who have a range of new or ongoing symptoms that can last weeks or months after they are infected with the virus that causes COVID-19 and that can worsen with physical or mental activity. Okay, and it looks like the majority of you said no, which is correct. An individualized assessment is necessary to determine whether a person's long COVID condition or any of its symptoms substantially limits a major life activity. On September 9th, 2021, the EEOC actually released guidance on long COVID and announced that it agreed with the analysis of long COVID by the Departments of Health and Human Services and Justice. EEOC technical guidance about COVID-19 and ADA disability in the employment context will be released in the coming weeks, and we will be sure to keep you abreast. But for now, we know that if a person with long COVID has a disability, if the person's condition or any of its symptoms is a physical or mental impairment that substantially limits one or more major life activities. And that's that long list of activities and examples that Demetrius provided earlier in the webinar. So people whose long COVID qualifies as a disability are entitled to the same protections from discrimination as any other person with a disability under the ADA, Section 504, and Section 1557. Which means that they are entitled to full and equal opportunities to participate in and enjoy all aspects of civic and commercial life. And this also applies to higher education institutions. You may need to make changes to the way you operate to help accommodate a person's long COVID-related limitations, including things like providing additional time on a test for a student who has difficulty concentrating as a result of their long COVID, or modifying a policy to allow a person who experiences dizziness when standing to be accompanied by their service animal that is trained to stabilize them as a direct result of their long COVID. So now I'm going to turn it over to Demetrius to continue our conversation about COVID, specifically as it relates to vaccine mandates.
Thanks, Teresa. But first, before we transition, we received a question that I just wanted to, and you can feel free and chime in, but I'm going to start off. The question is how do regulations differ from service animals when it comes to emotional support animals? And truthfully, I mean, the easy answer is that they're treated pretty differently. A service animal, just by definition, is going to be a dog or, in some instances, a miniature horse that's trained to perform a specific task for an individual with a disability, whereas an emotional support animal may not be trained to perform any task, but provides support to an individual with a disability. And so the ESA rules are typically governed by either an institutional policy or the federal laws that concern that are actually housing laws from the Fair Housing Administration. And so typically an individual would need to go through the institution's accommodation process to determine whether or not an ESA is an accommodation for them. And so typically at most institutions, that is routed through their accessibility office or their accessibility coordinator. Whereas, as Teresa said, you have a very limited inquiry when it comes to what we may ask and to review service animals. And so quite a bit different treatment. Also, as I stated, the service animals could be a dog or miniature horse, whereas an emotional support animal could be a wide variety of animals. So I know this is a hot topic, and it's growing every day as more schools, more institutions decide, what they're going to do with both employees or students. And I hope to answer that this will answer some questions. In true lawyer fashion, though, it's going to depend on where your institution is located. Universities often follow the state law when it comes to these requirements for vaccinations. We do know that measles, mumps, rubella, meningitis, those vaccinations have been required by institutions for a long time. But right now, as the state-specific law is developing, seemingly monthly, you really need to look at the laws in your specific state. It also can depend, and we'll talk about this here in a few slides, it can depend on whether your institution is a public institution or a private institution. So the big answer is it depends on the location and how, the status of your entity. But let's go through some tips. So medical and religious exemptions. Most states grant vaccine exemptions for medical or religious reasons. People can be granted an exemption from vaccination if it contradicts the phrase you often see as sincerely held religious beliefs. However, there are a few states that do not allow religious exemptions, and those are California, Connecticut, Maine, Mississippi, New York, and West Virginia. And there are a small number of states that allow for philosophical exemptions. What's philosophical exemption? So they're not restricted to religious beliefs, but it may include moral, philosophical, or other personal beliefs. And this is a chart that was put together by the National Conference of State Legislatures. This is from April of this year. From my understanding, it's still current, but this shows the exemptions by state. And so I think we received the comment that the link isn't working. We'll check that out and see if we can get the link updated before we circulate the slides. So I apologize for that. But this is just here for reference. And I think this is just a good idea to look at this and just understand that it's very state and territory. There are distinctions based on state and territory. So what states currently prohibit proof of vaccination? You can read these on your own, but there are quite a few states that are currently prohibiting proof of vaccination. Some states specifically mention higher educational institutions in their statutes. For example, the Ohio Governor Mike DeWine just signed House Bill 244, which prohibits public K-12 schools, colleges, and universities from requiring that students or staff get a COVID-19 vaccine. So let's do a little pulse check here. So next poll question, my institution has a mandatory vaccine policy in place. Yes, no, I don't know. Okay, it looks like we're sitting right about 65% of those of us that are participating institutions do not have a mandatory vaccination policy in place. So as we look at the landscape right now, and this information came from the Chronicle last week, so it's up to date, and this link should be working. But it looks like there are approximately 589 campuses as of last week that require the COVID vaccine. Most require for all students, although some only require for residential students. And also, this is just such a great map. You can look and see, where the public institutions are based on color. You can look and see where the private institutions. This was a wonderful infographic that was put together by the Chronicle. And so next I want to talk about Clausen, the trustees of Indiana University. And in this case, 8 students sued Indiana University to block its vaccine mandate, which does not require proof of vaccination and is in effect for the fall of 2021 only. The student plaintiffs expressed various reasons for opposing the mandate. Those included religious objections, prior COVID-19 diagnoses, concerns about developing acne from wearing masks, and also beliefs that vegans and pescatarians are less likely to experience serious illness. And there was also a claim that masks are just silly. And so the students claim that the vaccine mandate imposed by the university violated the 14th Amendment of the Constitution. And as a result of the review, out of the U.S. District Court for the North District of Indiana, the court determined that recognizing the student's significant liberty to refuse unwanted medical treatment, the 14th Amendment permits Indiana University to pursue a reasonable and due process of vaccination in the legitimate interest of public health for its students, faculty, and staff. That's a quote from the opinion. In short, the balance of harms and the public interest favor the university. And so the plaintiffs in that case filed for injunctive relief with the U.S. Supreme Court, and the application for injunctive relief was denied by Justice Barrett on August 12th of 2021, so about a month and a half ago. And so what are we seeing when it comes to these vaccine mandates? Well, we're seeing that they can be difficult to enforce, and that may be why some institutions, why your institutions here on this webinar have not decided to move forward. As you proceed in moving forward with some type of mandate, you must consider how is your institution going to process exemption requests? How are they going to vet those? What will the penalties be if a student falsifies information? Are we going to start looking at individual requests to determine, whether or not they are sincere or whether or not they're false? Also, some institutions may have 40, 50, maybe even upwards of that students on their campus, and so just the influx of receiving those and the staff power to go through and review all those. So those are reasons why these mandates may be difficult to enforce on a campus. And so, I think what we are seeing across the higher education landscape and across the country is that no similar than other industries is vaccinated students have been offered prizes and greater access to events or on the campus if they are vaccinated. But on the other side of the token, there are some schools that are banning non-vaccinated students from campus. For example, I know that there are some schools that have required for this semester that unvaccinated students file petitions for either being able to study remotely or to take leaves of absences this semester if they chose not to receive a vaccination. Also, I think you can look and see there are lists out there of institutions that have made the decision that based on not having online courses or not making online courses available, that unvaccinated students were not allowed to register for courses this semester. And so as this develops and as we approach enrollment time, I'm sure like your institution, like many others are reviewing, where we stand with our fight against COVID-19 and making some type of determinations for next semester, whether you're going to stay with the same policies or get back to allowing unvaccinated students to come on campus. And so it's evolving, but the big takeaway here is just know your state's laws. For example, in Texas, public universities cannot require a vaccination, but private schools can. And in June of 2019, so before the pandemic, New York State passed a bill no longer allowing religious exemptions for vaccinations in school. In New York, public universities cannot allow for religious exemptions, while a majority of the state's private universities can. And so it's really state specific. And so let's transition a little bit to some employee examples. So school employees, so they're subject to reasonable accommodations. School may require most vaccinations for employees physically entering a workspace. If an employee cannot be vaccinated because of a disability, the employer cannot require compliance unless the individual would pose a direct threat to the health and safety of others in the workplace. So what is a direct threat? It's a significant risk of substantial harm that cannot be eliminated or reduced by a reasonable accommodation. And so when you're going through the direct threat analysis, you're going to look at two things. And so you're going to look at, first, is there a direct threat? And then the second step is, can a reasonable accommodation either reduce or eliminate this threat? And so the four factors that you're going to look at in doing this direct threat analysis is the duration of the risk, also the nature and severity of the potential harm, and the likelihood that the potential harm will occur, and imminence of the potential harm. And so as we're thinking about accommodations that we may be able to offer in the workplace, some common accommodations are requiring the employee to wear a mask, giving the employee a staggered shift, improving ventilation in a work environment, limiting an employee's contact with others, and then of course telework if it's possible for them to perform their duties that way. And so as we think about this, I just want to remember that the ADA requires employers to keep confidential any medical information they learn about an applicant or an employee. And so, when it comes to employees that request accommodations, this is something that we need to keep confidential. And so when it comes to COVID-19 specific vaccine requirements, many states are prohibiting employers from mandating COVID-19 vaccinations. So similar to the student context, it's very state specific. Some prohibit all industries from requiring vaccines. Others permit mandated vaccinations only for healthcare workers. We have a wealth of COVID-19 information, research, guidance on our website including we have a 50-state survey when it comes to employment, the employment context within your state. And so I encourage you all, we'll send this out tomorrow, like I said, check out the link, check out some of the materials. Our L&E group has done a fantastic job of keeping this updated as this world has been evolving. So next, I'm going to turn it over to Teresa, and she is going to take us home on ADA issues on campus.
Thanks, Demetrius. And before I start on this section, we received a question about what can higher education institutions and businesses in general provide their employees and family members with regarding the vaccinations. And you can give information to your employees to help educate them about the vaccines. You can help raise awareness about the benefits of getting vaccinated. And you can also send out emails addressing common questions and concerns. And similar to what we've been seeing with students, you can also provide incentives to your employees who received COVID-19 vaccinations. So just wanted to answer that question. So now, like Demetrius said, I'll transition to the ADA on campus. So as most of you are aware, the disability services offices are really your prime spot to be able to help your students with any sort of accommodation requests. And Demetrius and I are seeing an increase in requests for accommodations to disability services offices that are what are called invisible disabilities, including anxiety and ADHD. And we are able to partner with our higher education institutions to act as a resource to help those students and help enhance access to campus, including handling accommodation requests. Disability services offices are also able to provide counseling and training to employees and staff. So for students on campus, there's an interactive process. And like Demetrius mentioned earlier, unlike K through 12 education, accommodations are not required or provided automatically by the school. Rather, the student must request accommodations and provide documentation. Then the student and the school must work together to achieve the best possible outcome. And like the name states, this is really an interactive process where the student can interact with the university and provide feedback about proposed accommodations, and after trying them can request additional and adjusted modifications and accommodations. So this is truly an interactive process, and the ability for the school and the student to come together to find a way to provide a good outcome for the student. However, we wanted to provide you with some pointers and accommodation request reminders. So approved accommodations can vary from person to person and from environment to environment for students, even if all of the students have the same disability diagnosis. And documentation of a specific disability does not translate directly into specific accommodations. Rather, this is an individualized case-by-case process. And there is an option for temporary accommodations, and this can help the university and the student determine whether ongoing accommodations are appropriate, but it's important to know that temporary accommodations do not reflect a determination that the university will grant ongoing accommodations. Schools are only obligated to provide reasonable accommodations, and it is not required to fundamentally alter your programs to accommodate one student. Thus, it's important to remember that not all accommodation requests need to be granted. We've provided you some common accommodations that we've seen, including extra time on exams, assistance from note takers, and allergy-friendly meal options available at dining halls. But again, what you need to focus on is whether it's reasonable or not. So to help with that, we wanted to provide you with some tips and tricks as you go through this process. First, from the onset, we think it's really important to educate your incoming students. Like we discussed earlier, the college environment follows legal guidelines that require the student to disclose his or her disability status and request accommodations. But it's entirely possible that your students might not know that. So we recommend talking about this at your orientation and reminding students about the difference between the accommodation process from high school to college, including their need to have documentation and their need to request reasonable accommodations on their own. We also think it's a good time to remind students just from the onset that the school is not required to provide personal services, nor is the school required to provide accommodations that impose undue hardships or change the nature of the program. We also encourage our schools to be flexible. We have seen that the pandemic has forced colleges to be more flexible than ever. Some examples Demetrius and I have seen include students with partial or full hearing loss might not have required a translation service in a small classroom, but now they need video lectures captioned. Or we've seen students who are blind who have had their typical coursework translated into Braille, but we've had to figure out how to get that mailed to their home address with everyone being virtual. So we encourage you to be flexible and don't make assumptions about a student's abilities or necessary accommodations, especially when there's been a transition from in-person learning to online learning. We also encourage you to be consistent, and we have seen that the best way for a school to be consistent is that eligibility for services under the ADA is the job of disability services personnel, not the faculty. So we really encourage schools to have a centralized resource and encourage students to go there so the accommodations are the same for all of their classes as opposed to teacher dependent. We also encourage your disability services office to be visible and make sure that your recruiting materials are out there, that students know who you are and where you are, and that the information is accessible both physically and online. And this visibility really helps assist students in knowing that the university has policies in place to help ensure that they're able to attend classes in a way that is reasonable for both the university and the school, and to know who to talk to if they need some sort of accommodation. Finally, we think it's best when our disability services offices are proactive and make the accessibility universal. And some examples of that are colleges will have nut-free and gluten-free options just readily available in a dining hall as opposed to a student making a request for that. We've also seen schools who do just regular routine maintenance on automatic doors to ensure that they're working on their campus buildings and the buildings are accessible as opposed to waiting to hear that a door isn't working. And then we think it's important to partner with other campus departments, so you can go to athletics to make sure that your students, athletes know that the disability services office is there to help, going to different residential halls and interacting with students and letting them know that you are there and you're able to help if a student needs an accommodation. And we've really seen that when our disability services offices are proactive, that it's a better resolution for the school and the student. So it looks like we have a few minutes left. Demetrius, if there's any questions that you've seen that you have any answers or insight to.
Yeah, I'll go over a few. We have a few minutes, and so I want to try to answer some questions. This question box is really full, so it's not going to be possible to get to every question. But Teresa and I will send individual email responses to these questions. So I really do appreciate you all attending, and I appreciate you all having so many questions. But here's one that I want to talk about. It says if a student with a hearing impairment requests that their professor wear transparent masks as a reasonable accommodation, if masks are required on campus, but the faculty refuses to wear the transparent mask because they are concerned with the effectiveness of a transparent mask versus the effectiveness of an N95 or other mask out of an abundance of concern, RE-COVID. So this one, it says the question is, can the institution require the transparent mask overriding the professor's health and safety concerns? I'm going to give you a lawyer answer here and say, first of all, talk to your local counsel about this because you want to make sure that you're giving consistent legal advice for your jurisdiction and your institution. But some things here that I would think about, and maybe this helps get to the answer. So in this type of situation, you should accommodate the student with the hearing impairment, but this may be an example, as I alluded to during one of my section, the specific accommodation request that they make, you should use that in an attempt to address the student's impairment, but you don't have to give the specific accommodation that's requested. And so, as I would approach this scenario, I would look at other ways and try to figure out other ways in which the student has access to the lecture or the classroom materials without, if there's a situation, I would assume in this scenario, based on this, the faculty member doesn't want to put themselves at risk. So what other ways, is there a way that we can, provide, an audio recording at the end of each session? I would try to think outside the box a little bit here and see, how can you give this student access to, in essence, the lecture and the course, while still providing the faculty member with the protection of wearing the masks. And so that's how I would address it. I know that's not just a yes or no, but it really would depend. Teresa, do you see any others that you want to touch on?
Yeah, so we have a question about, can you require vaccines for students residing in residence halls? And the answer is generally yes. Demetrius and I have seen it with the meningitis vaccine, where most of our higher education institutions require students living on campus to have that vaccine, or to provide some sort of waiver and have either a medical or religious exemption, like what Demetrius touched on.
And so I received another question, Teresa, and feel free and chime in. This was relative to service animals, but let me see if I can answer. So with the service animal, can you ask what type of animal? You want to stick to the two question inquiry, but just for your knowledge, the approved service animals are going to be a dog or a miniature horse, and so that's also an inquiry that would be readily apparent. You would be able to tell if they showed up with some other type of animal, but if you receive communication from a student or a patron about allowing the service animal, I would stick to the two question inquiry that Teresa discussed.
And we received another question about potential accommodations for online classes, and there are features available. I think Zoom has a transcription, and that is something where you can ask your faculty to ensure that that is on and show students how to turn that on. That's a relatively easy accommodation to be able to provide when classes are online.
I received another question about can an institution ban emotional support animals in dorms? And my answer to that would be no. The Fair Housing Act is going to allow students that need an emotional support animal as an accommodation to their disability. They would be able to have such an animal if it's determined necessary to provide them the accommodation. And so typically that would run through the accommodations process. I know what a lot of our clients are doing is, developing, emotional support animal floors, some buildings on campus but some of those issues can be tricky there too. You don't want to, in essence, put all students with disabilities on one floor or in one building, so you need to be careful about that. But there are certainly ways that you could accommodate the student that needs the emotional support animal to provide an accommodation for their disability and address any concerns that other students may have with sensitivity to animal or pet dander or fear of animals. And so the short answer to that is no, you can't just outright ban it under if you have housing under the fair housing rules. And so with that, I'm going to turn it over to Teresa for some closing remarks.
Thanks, Demetrius. And we received one last question about HIPAA and as it relates to the vaccine. So the HIPAA privacy rules are rather limited in that they prohibit the release of protected information by others without your consent, but it doesn't apply to a person about whether you can or should answer questions about your vaccination status. So hopefully that answers that question. But thank you to everyone here for joining us for our program today. We hope that the information that we discussed during this webinar was helpful to you and your institution. If you have not already, please click on the survey icon at the bottom of your screen to complete our short survey. Your feedback assists us in providing quality future programs, and we look to that feedback in determining what topics to talk about in future webinars. As a reminder, this program is pending approval for continuing legal education credit. Please download the Certificate of Attendance from the certificate widget at the bottom of your screen. A recording of the webcast will be available tomorrow for watching and sharing. Once available, a link to the recording will be emailed to you. Please be sure to join us for our next webinar on digital accessibility on October 27, 2021. This concludes our webinar. Thank you.